So we're going to talk about bylaws today. We'll get to bylaw enforcement regime towards the end of the presentation, but before we talk about bylaw enforcement regime, I always think it's really important to understand bylaws generally, because as committee members, for those of you that are committee members, you're not going to be able to participate in a proper enforcement regime unless you understand bylaws. And I think it's really important generally to understand bylaws anyway, because at their essence, bylaws are the contract between the owners and occupiers of the scheme, and they're the rules that are meant to govern harmonious living within the scheme. Now, so what are bylaws? The legislation sets out what bylaws may provide for, so it's not carte blanche. You can't put in essentially whatever you like. The legislation is very clear as to what bylaws are to provide for, and they may only provide for the administration, management and control of common property and body corporate assets, and then importantly and critically, for the regulation of the use and enjoyment of lots, common property and body corporate assets. And it's that use of the word regulation that's critical. So I'm sure you're all aware that a bylaw which bans pets altogether, strictly prohibits pets, is now ruled as an invalid bylaw. The reason it's been ruled invalid is because the adjudicators have said a strict prohibition is not a regulation. So bylaws can only regulate the use and enjoyment of lots, common property and body corporate assets. Now, does everyone know where to find their bylaws? Often I get asked by lot owners at the end of these talks, well, where do I find my bylaws? Do you all know where to find them? Yep. For those of you that don't, they're in the community management statement in Schedule C. When I first started doing body corporate law almost 20 years ago now, we were governed by what was called the Building Units and Group Titles Act, and whenever you changed bylaws, you had to put in a separate piece of paper. So if you changed your bylaws 10 times, under the Building Units and Group Titles Act, you needed to go and get 10 bits of paper and sit down with them all together and see which were added, which were deleted, to work out the bylaws that were applying to your scheme at any given time. Under the Body Corporate and Community Management Act, you don't need to do that. Whenever you change your bylaws, either you add a bylaw or you repeal a bylaw or you just change some wording to a bylaw, your body corporate needs to go and lodge a whole new community management statement. And the reason for that is so that at any given time the bylaws currently applying to the scheme are in one document. What's important to note though is that a bylaw, a new bylaw or a changed bylaw, is only effective from the date that the new CMS is recorded in the Department of Environment and Resource Management. So it's critical to know that a bylaw doesn't become effective upon the owners resolving to adopt that bylaw. It only becomes effective upon the new CMS being recorded. Now, the issue with that, of course, is sometimes, occasionally, bodies corporate resolve to change a bylaw, but for whatever reason, the new CMS doesn't get registered. So even though the body corporate has adopted that bylaw, it doesn't actually apply to the scheme because it never got registered. So it's critical for those of you that are on committees that if your owners resolve to change the bylaws, that you ensure that your new CMS is ultimately registered, because unless it's registered, that bylaw will not be valid. And it's very important with respect to, for example, if you're granting someone the exclusive use of a car park, if that grant is not recorded, then for all intents and purposes that grant doesn't exist, and of course that creates problems when that person comes to sell the lot. So it's critical to make sure that if a motion's passed changing the bylaw, that's not the end of the road. You've got to follow through and make sure that it's recorded. And of course, if you engage a lawyer to do that, that's really their job as opposed to the committee. The other thing I want to say about recording of bylaws is that recording doesn't equate to validity. The Land Titles Office don't look at the bylaw that's been put in. They just look at the form of the document that's put in, and if it's in a form acceptable to the registrar, it will be registered. They won't concern themselves with the wording of the bylaw. So just because a bylaw has been recorded doesn't mean that that bylaw is valid. If someone wants to argue about the validity of the bylaw or the motion which the owners resolved to change the bylaws, then that owner needs to go and lodge an application in the Commissioner's office seeking an order that the bylaw is invalid. If that order is forthcoming, what will happen is that the Commissioner will normally make an order simply saying that the body corporate record a CMS deleting the bylaw. The registrar might order that the bylaw be recorded in a different form. For example, with pet bylaws, if you do have a no pet bylaw and that gets challenged, then what will happen is that the registrar will order that the body corporate record a new CMS, generally adopting the pet bylaw in the schedule attached to the Act, which essentially says that you can keep pets subject to conditions imposed by the committee. With respect to pet bylaws, because that's one of the more contentious ones, what we've done is we've drafted a pet bylaw which has about 10 conditions, and if that were challenged, we'd be fairly confident that those conditions would be found to be reasonable. What bylaws cannot do? They can't be inconsistent with the Act or the module. So you can't have a bylaw which says, for those of you that have resident caretakers on the scheme, you can't have a bylaw which grants a resident caretaker exclusive use of the storage area. The reason you can't have that is because if that storage area is used in furtherance of the caretaking duties, the Act says that you can only grant that by what's called a Common Property Occupation Authority. So that bylaw would be inconsistent with the Act and therefore invalid. You couldn't have a bylaw which says we're not going to have annual general meetings because the Act says body corporates must have annual general meetings. So can't be inconsistent with the Act or the module. Second one comes up a bit. If a lot may lawfully be used for residential purposes, the bylaws cannot restrict the type of residential use. So if a bylaw cannot prevent a lot from being used for short-term letting, that comes up a lot. You might have predominantly owner-occupiers, you might have predominantly long-term tenants, so you can't pass a bylaw saying, well, you can only rent your lot for greater than 90 days. That's not allowed under the legislation. A bylaw must not discriminate between types of owners. That's reasonably self-explanatory. You can't have a bylaw which, for example, says only owners can use the pool and tenants can't use the pool. If you're an occupier and you're at the scheme, you have rights to use the common property equally with others. Although that said, an interesting matter came across my desk on Monday, which I haven't been asked to give formal advice yet, so I actually haven't ascertained what the answer would be under the current state of the law, but the situation was, it was a scheme in Brisbane, in the CBD, and an owner had rented his unit to someone, but the owner worked in the CBD, and to and from work, the owner was using the gymnasium, notwithstanding that the owner wasn't an occupier at the scheme. And the question that was asked of me was, is that lawful? As I said, I haven't had calls yet to ascertain the correct legal position, but my gut feeling would be that I would have thought an adjudicator would look dimly on it, because it's almost like, well, it's not almost like, it is double dipping really, that piece of common property is getting used twice, which affects then the repair and maintenance obligations placed on other owners. But it's certainly an interesting question, and if I get asked to provide a formal answer next time we have this seminar in Brisbane, I'll give you the answer. Sorry, seminar in Redcliffe, I'll give you the answer. A bylaw rather than an exclusive use bylaw must not impose a monetary liability. Some of your schemes may have a bylaw which says that if you're moving in and out of your lot, you've got to pay $1,500 to the body corporate manager to cover any damage that may occur. That bylaw would be invalid if challenged. There is a carve out there you can see for exclusive use bylaws. You can grant exclusive use, or a body corporate can grant exclusive use to a owner in exchange for payment, be that a one-off payment, be it rent, a licence fee, something like that. So there is a carve out for exclusive use. But as a general proposition, bylaws can't impose monetary liabilities. A bylaw must not be oppressive or unreasonable. That is the section of the legislation which owners who want to challenge bylaws generally hang their hat on. It's very broad. With the Commissioner's Office, it determines which adjudicator you get, will determine whether an adjudicator thinks something's oppressive or unreasonable. For example, you may have a bylaw which says you can only use the pool for 1 hour a day between 10 a.m. and 11 a.m. If that was challenged, or if I was an owner wanting to challenge that, I would say that that bylaw is oppressive or unreasonable. Ban the banner. A bylaw must not offend sustainable housing provisions of the Building Act. The example given most with respect to that is solar panels. You can't have a bylaw which prevents installation of solar panels purely on the basis of aesthetics. That's not to say that you can't approve or apply conditions to the installation of solar panels, and one of those conditions might be evidence that it doesn't affect the structural integrity of the building. But if you've got bylaws which simply ban solar panels purely based on aesthetics, that will breach the Sustainable Planning Act, the Building Act, and will, if challenged, be found to be invalid. Now, the reason I keep saying if challenged is bylaws are valid in your CMS until they're ruled invalid. So a lot of committees come to me and they'll say, well, we absolutely want a no pet bylaw. My obligation is to tell them, well, you can't have one because if it's challenged it will be ruled invalid. And committees will say, no, we're definitely a no pet scheme, we want a no pet bylaw. And the reason they do that is simply to act as a deterrent. For every 10 people that might buy into the scheme, those 10 people might look at, or want to buy into the scheme, those 10 people might look at the community management statement, see that there's a no pet bylaw, and say, okay, well, this is not the scheme for me because I want to keep Larry the Labrador, so I'll go and buy somewhere else. But of course, you will have people who are fully aware of the law, and we had one recently where it was a no pet scheme for the last 20 years, and a new owner has, of course, rocked on up on day one with Larry the Labrador. The committee's gone berserk, the other owners have gone berserk. I get a flurry of phone calls, and I, of course, had to be the bearer of bad news to say, well, regrettably, Larry's going to have to live there. And the inevitable question comes is, well, Larry's 15 kilograms, that's not good for a unit. Again, arbitrary weight limits are unenforceable, and the reason for that is Larry at 15 kilograms might be a very docile dog, whereas Billy at 2 kilogram terrier might be yapping all day. So pet bylaws are still cause of angst, notwithstanding that for some time now it's been reasonably settled law that you can't ban pets in community title schemes. But we'll see where we end up with that shortly. I'll be speaking about some legislative change that was in the wind but has been put on the back burner with the change of government in Queensland. Contentious bylaws. Towing. How many of you have troubles with towing or parking at your scheme? One, there's always one, two, yep, all the arms come up. Towing's a contentious issue, will remain a contentious issue until we have some legislative change. You'll all be aware, or should all be aware, that body corporates don't have an inalienable or unalienable right to go and tow a occupier's motor vehicle. And I specifically use the word occupier. What the adjudicators have said is that if there's an occupier illegally parked at the scheme, then the legislation sets out the rights of the body corporate, and those rights are to pursue the bylaw enforcement regime. They're not to just go and tow the vehicle. Different, of course, with visitors. If you can establish that there is a visitor illegally parked on the scheme, then there is no prohibition under the current state of the law for the body corporate to tow that vehicle. The difficulty, of course, is establishing what is a visitor's vehicle and what is an owner's vehicle. I would like to see, for what it's worth, and I confess my bias here. I'm a body corporate lawyer. I don't act for managers, I don't act for owners, so I guess I'm pro body corporate. I would like to see the legislation changed such that the body corporate has the ability to, at the very least, fine recalcitrant owners when it comes to illegal parking, and for that fine then to go into the sinking fund so that everyone at least benefits. And I think if people start getting fines, then that's really the only thing that's going to hit them. When it hits them in the hip pocket, that's really the thing that's going to stop them parking illegally. There is some thoughts around body corporates engaging local councils to essentially operate the same way that a local parking inspector would operate on the street, and be able to issue fines with respect to illegally parked vehicles on common property. That said, like PECs, I still have a lot of committees who say we want to insert a towing bylaw into our community management statement, notwithstanding that we know that it's very difficult to just go and tow a vehicle. Again, the reason is deterrent only. Body corporates will tow the vehicle. Some body corporates will tow the vehicle, notwithstanding they haven't issued contravention notices, and the owner then goes and gets the vehicle from the parking compound, pays its his or her $400 to the towing company, gets the vehicle back. It's then incumbent upon the owner, if they so desire, to lodge an application in the Commissioner's office seeking reimbursement by the body corporate of the money that they've paid to have their vehicle released. Now, those of you sitting in the room might go, oh, you know, that's not too bad an outcome for the body corporate. For every 10 cars we tow, we might have to give $400 back to the owner a couple of times. It's not really the reimbursement of the parking or the towing company's fee that causes me concern. What causes me concern is that the agreement between the body corporate and the towing company generally contains an indemnity by the body corporate in favour of the towing company that any damage caused to the vehicle in the course of towing is not the responsibility of the towing company. So I act for a lot of schemes in the CBD, a lot of schemes on the Gold Coast, schemes in Redcliffe, which are very prestigious schemes, and it's not unusual that there's a $400,000 Mercedes illegally parked or a $500,000 Aston Martin illegally parked. If that's damaged in the course of towing, and the towing company can put their hands on their heads and say it's not my problem, then the body corporate may well be exposed to a lot more than having to reimburse the $400 towing fee. So towing, still contentious, will remain contentious. Pets we've already spoken about. For what it's worth, I don't dislike animals, I quite like animals, but I'm a firm believer that you should be able to have a scheme which says that there are no pets allowed. And the reason I believe that is the legislation already sets up a mechanism by which the owners can change the bylaws. So it's already a democratic process. If you've got a no pet bylaw and the owners over time want to change that bylaw to allow pets, well then an owner can put a motion on a general meeting agenda to ask the other owners by special resolution, so it's a fairly high threshold, to change their bylaws to allow pets. And at least in that way, the majority of owners, in my view, get their say, and that would be more palatable than, in my view, an adjudicator just going, no, a strict prohibition is not a regulation, therefore you're allowed to have pets. That's just my view for what it's worth. I suspect down the track there may be some legislative change, certainly with respect to towing and pets, such that whatever rule might ultimately come with respect to towing and pets will be found in the legislation as opposed to the bylaws. Before the Liberal Party got thrown out of office in Queensland, Jared Blige, for whatever you may think of him, certainly was quite receptive to the review of the Body Corporate and Community Management Act, and we found him to be to have a lot of common sense and a lot of drive in trying to reform the Body Corporate and Community Management Act. We haven't found that same receptiveness with the current Attorney General. In fact, the entire review of the Body Corporate and Community Management Act has been on the back burner, and as it stands at the moment, we're not really sure whether that review will now ever see the light of day, whereas under the Liberal government it was very close to being enacted into legislation.